in the alternatives assessment, what the state's Department of Toxic Substances Control will do is identify those priority chemicals, chemicals where there is widespread exposure, chemicals of high toxicity, and then pair that with certain products that use those chemicals. And for that pairing, chemical and product, the manufacturer will be required to prepare an alternatives analysis. Remember the name of this law, safer substitution. What you're trying to do is drive consumer product companies to do an upfront analysis and then substitute some other functional chemical for the dangerous chemical that's currently being used in the product, and to present that analysis to the government and have the government then much earlier in the design chain have its input into whether or not you can sell the product or what conditions will be required for you to sell it. Very much like a government agency allowing a project to go forward, but only with certain types of mitigation involved in the project. So the manufacturer would prepare the alternatives analysis, would identify its preferred alternative, and then expose that analysis not only to the agency but to public comment. Sounds a lot like NEPA, doesn't it? All consumer products are covered. The ones that are exempted are those that are exempted by other federal statutes. You often see these exemptions in other laws. So food, drugs, pesticides, pesticides covered by FIFRA, food and drugs covered by the FDA. So that's why those products are exempted from the Green Chemistry Act. The chemicals that are regulated are drawn from the various databases, and you can see the various types of somewhat overlapping chemical systems that are involved. Candidate chemicals have certain types of hazard traits to them, and they're ranked in the green chemistry system for their priority to be regulated. So the initial party that's responsible to comply is the manufacturer, and that makes sense. They're the ones that have the most information about the product, then followed by importers if the manufacturer is not available. Can anyone tell me, why do you do that? Why would you ever have an importer responsible for the alternatives analysis instead of the manufacturer? Can anyone tell me? Because many manufacturers are in Asia. Some of the manufacturers in China are beyond the jurisdictional reach of the United States. And so you have to have somebody responsible for this process. And so you pick on the importer. And then last in line is the retailer, because again, they probably don't have perfect information either, but they stand in the shoes just in case we need to have somebody responsible for this law. Lynn, good afternoon.
Peter?
You are perfect timing. I've stolen a little bit of your Tosca thunder, but I'm sure you'll re-thunder and top of me. So this is how it's done. This flow chart, which is in your material, show the identification of priority chemicals, followed by the products, the priority products, followed by how an alternative analysis is going to be done, and then it ends up with the regulatory response, the conditions that will be imposed. Those conditions can range all the way from a complete ban of the sale of the product to something that you have to do, a substitution of a chemical or a label that has to be placed on the product. And the life cycle analysis includes not just the pathway of a consumer using the product, it also includes the pathway of a worker, an employee putting the product together, and the end of life. What is the impact on a municipal waste landfill from a disposal of the product? It's this life cycle analysis which is intrinsic to the green chemistry rules.